One of the reasons that rhetoric, the study of it and the science of it, was invented in classical Greece was because of the Athenian democracy. There were democracies in other cities as well. The point about a democracy is that all the citizens needed to be able to talk and express their views, or at least understand quite complex speeches before they voted. In Athens, there were about 30,000 male citizens, and they all met on a hill near the Acropolis with the famous temple, Pnyx Hill it's called, and usually it would be 10 or 15,000 people for important decisions, even more, the maximum number if it was something like, should we go to war? And any citizen could stand up and speak. In practice, it wasn't really approved of if somebody under 30 did. They thought this was sort of cocky young men. But it wasn't outlawed. If you wanted to speak, you could stand up and make a speech. And then the votes were by hand. There were also big speeches made on battlefields, but most of the rhetoric that was needed was in the law courts, because with the democracy became a huge amount of litigation. There was no Crown prosecution service. Every case that was brought always had to be brought by an individual, but that could still be a very political case. So one individual could prosecute another for corruption in political office, although we've got about 40 or 50 actual extant surviving law court speeches, and they range from murder trials to theft to assault to people who have let their vine trees clog up the next door neighbour's plumbing. I mean, it's all kinds of different cases, and they're heard in different kinds of court. We know certain really great speakers existed and worked magic through their rhetorical powers. So the general was equivalent of a member of the cabinet. There were 10 of them elected every year. Pericles was said to be the greatest orator of them all, and he got re-elected every year for 30 years because he was just so persuasive, and his ethos, the way he presented himself, was so trusted and plausible. Anybody could learn to speak, this was believed. Demosthenes, who was the second greatest of all ancient Greek orators, had a stammer and a very thin voice as a child. So he did all kinds of exercises, including going and shouting at the sea with a mouthful of pebbles to develop his breathing and the volume of his voice, and managed to cure his stammering. But there were courts and trials everywhere and all the time. As we know most about the classical Athens ones, like today, there were different types of court for different kinds of offence, but there were more. So there were specific courts for corruption trials, trials to do with money, a very particular court for murder trials, which was open air because they believed that a polluted murderer somehow could infect you, unless if you had a roof over it. There were courts for every different kind of theft or assault, whatever. And we've got the remains of one or two of them. But the actual procedure at the trial was completely different. So you've got the prosecutor who's decided, say, to take on somebody because they think that they assaulted them in the street. We have many like that. And you would tell the magistrate that you were going to bring that trial. Your court would be allotted, as would your jury. There were no separate judges. The jurors were judge and jury, and there were hundreds of them. So a normal trial in classical Athens, there were 500 jurors. They were chosen from volunteers, and because it was paid a decent day's wage, enough to feed you and your family. An awful lot of the jurors were poor old men, right? They were no longer needed to work in their farms or factories. They'd sort of retired, and they would put their names forward to get this extra pay over their pension. And there was a board every year of 6,000, for which any trial, 500 were selected entirely by lot. Right? So blind lot. So that's try to avoid any risk of corruption. So you've prosecuted someone or you have been prosecuted, you've got to go along to the court. There are 501 guys, because there has to be any odd number, maybe 1,000 for more important trials, plus, because it was huge public entertainment, lots of bystanders. It was always done in front of, lots of people wanted to hear the goss and the scandal and hope for some excitement. You had to make your speech. The prosecutor made it first, laid out his case, hopefully using ethos, pathos, logos, and all that persuasion. And it was measured in length by a giant egg timer with water in it called a clepsydra, which just means water stealer, giant water clock. And he had to stop, even if he hadn't finished his speech at the end of that. He could produce witnesses, but they had to be within the time of the water clock. He could produce documents. He could produce, a bandage or a weapon. He could, produce all his evidence, but within that time. And then the defence speaker had to stand up, the defendant himself, and answer all those points. That must be incredibly nerve-wracking, especially if the guy prosecuting you who suddenly produced new evidence, or you'd have to think on your feet. You had to do it yourself. You could go to a professional speechwriter for advice on what to put in your speech if you got money. It was expensive. If you were a poor guy, you probably wouldn't even have that resource. You might get your friends to. Then you had to learn it off by heart. People who had to use notes were laughed out of the court. Being able to do it, just stand up and do a combination of memory and improvisation was crucial. And after that, these jurors went off and put a pebble or a lump of wax scratched to say guilty or not guilty in pots. They were not allowed to consult or talk to each other. They just had to vote. And then the votes were counted. And if you were held innocent by 251 or more, you walked. If you were rendered guilty, then you had to go through it all again. The prosecutor would make a speech demanding that you be executed on the spot or tortured or given such and such a fine. You had to then plead for mitigation of the punishment. You couldn't then say you were innocent, but you had to say, how about I just pay this fine? Or how about I just give him money to mend his broken plumbing? A lot of people then brought on their little children to hold out their little hands and plead with. You could use any emotional tactics you wanted. We've even got one law court case where the defendant threatens to kill himself on the spot, right there. Then the jurors went and voted again for which punishment they should go for. So it's not like a judge giving down a sentence. It's them deciding how harsh to make the punishment. So this is extraordinary difference between courts today and courts in the ancient world. One of the most interesting questions, I think, is whether you think you might have done a better job than whoever your defence barrister was. Do you think you could have made a better job of it? Well, we very much hope that once you've studied rhetoric with Aristotle, you will be able to speak as plausibly as even the best-hearted and most experienced lawyer.